I call a member for Heffron.
Mr Acting Speaker, I rise to contribute to the Children's Procedure Amendment Child Sexual Assault Evidence Pilot Bill 2015, and I endorse the remarks made by the Shadow Attorney General and a member for Liverpool. I welcome this bill as the next step on the process of trying to protect vulnerable witnesses who are giving evidence in court of these heinous offences. I wish to add something to the debate from my experience as a public defender for 25 years and also for several years as a Crown prosecutor who has either prosecuted or defended hundreds of these cases. These are heinous offences. There's a Royal Commission currently, as we all know, taking place at the moment, which is dealing with these sort of offences that arise from a variety of institutions. But I regret to say, if you speak to police officers, they are only scratching the surface. These horrendous offences are rife as they have been for centuries. The last time I spoke to police a number of years ago in relation to this, they estimated 1 in every 5 people have been sexually assaulted at some time in their life, and those figures themselves are quite frightening. The effect and impact upon the children who have been sexually assaulted scar them for life, and very few people successfully are able to get over it. Having said that, I want to make this point, and that is that it doesn't matter whether you prosecute these offences or whether you appear for accused or whether in fact you are the trial judge. They are extremely difficult criminal proceedings to participate in. The whole nature of the function of barristers and judges are to be objective and approach their tasks on an objective basis. And seemingly at times they are required to appear as in fact are dispassionate, and that can somehow cause the wrong impression given to particularly the vulnerable victims. The Children's Champion suggestion that has arisen from a variety of inquiries is quite an outstanding suggestion to pilot. The difficulties that are faced by the Crown when it brings proceedings, although at times resourced by witness assistance officers, in having somebody look after and protect these vulnerable victims whilst at the same time trying to get matters ready for trial, has always caused considerable difficulty. The Children's Champion is a very, very worthwhile suggestion. I commend the Attorney General and for those who have recommended and advised that course. It's been successful overseas, and that is something that, if it's properly resourced, will add considerably to justice being provided in respect of these heinous offences. The issue that is also suggested in this pilot program is the taking of evidence in advance. For many years now, evidence of the child's complaint, their initial complaint and interview, has been taken in advance and has been recorded and subsequently played at trial. This pilot program is going to require cross-examination and re-examination also to be recorded. Now that sounds like a good idea, but in practice I caution the attorney, and it's something that needs to be monitored in respect of the implementation of it. It will require counsel to be properly briefed on several occasions. That will require legal aid to be resourced and public defenders to be resourced to be able to prepare, in effect, 2 trials for the same offence. Whilst it seems, for those who are not involved within the system, probably don't understand its actual implication in the administration of justice. But the fact of the matter is that at the time the child is cross-examined under this pilot program, counsel would have to be fully briefed as if he were briefed in respect of a trial. And usually, it doesn't matter what anybody says, what any rules of the court say, counsel are normally not ready until the first day of the trial in any event, so this will require them to be ready twice. The other issue I want to draw to the attorney's attention as a matter of practice, and it seems to be something that has crept in over the years, in not making available to counsel the videotape of evidence, and this is going to also incorporate the videotape of the cross-examination and re-examination, where arrangements will be made for counsel to view them. Now, I certainly understand and support the concept of not giving that evidence to an accused person. However, as far as lawyers are concerned, they will need to study that evidence carefully, because it will be the demeanour as it appears on the videotape, not just of the evidence in chief, but the cross-examination, which is substantially longer, and the re-examination. It may well take several days to view the evidence that is going to be played in a trial. So making arrangements for counsel to sit somewhere for a couple of days to view the evidence. I don't know why members of the bar are no longer trusted to be able to receive the things on their undertaking that only they will view it. But I would have thought that if the attorney is really concerned about that, she could ask for the bar rules to be strengthened to ensure there are protections. This is a practical thing. Are they going to sit in a DPP office for 2 or 3 days viewing the evidence, because they'll have to view it carefully? So that's something that I suggest the attorney gives some consideration to. The two other issues I want to refer to, whilst it's a very good idea to have specialist judges in this jurisdiction, I just want to warn the attorney, and perhaps it's a matter for the Judicial Commission, matters like this, whether you're judging, prosecuting or defending, whilst you might be seemingly to be dispassionate and objective, cases like this take their toll. I can imagine most of the judges on the District Court bench are delighted with this pilot program, because that means that they'll have less of these matters before them. But whether you're a judge or a prosecutor or a defender, these matters take their toll. The way the system of justice works is that there's an independent judge and they can effectively look after themselves. The Judicial Commission and the heads of jurisdiction will need to make sure that the judges who specialise in these areas are travelling all right and are not being impacted by the day in and day out nature of cases of this nature. When we read about it in the newspaper, that they can be sickening, but if you're spending all day and every day listening to the horrendousness of some of the heinous allegations in these sorts of cases, it does have its impact. The days of the old, bold lawyers and judges that can put up with any type of evidence, I think we know that that's no longer the case. So we need to consider what sort of support we're actually providing for the judges in terms of their own health. The other issue I caution the attorney about too, and would like some consideration given in the future while this pilot program is taking place, is this: that the directions that judges are required to give juries in criminal trials are so complex that those of us who have done hundreds of them see the jury's eyes glaze over after about 2 or 3 minutes. If you've ever heard a judge giving directions as to when the Crown are relying on tendency or coincidence evidence, actually either understand or pay attention. Judges are so concerned about making an error that they're generally reading out the standard directions, and that really impacts upon the ability to communicate. There are so many directions that are required to be given to juries that if those directions were given to you, you would have trouble following it. So there needs to be a review, particularly in this area of the law, to simplify the nature of the judge's directions to the jury. The last thing any of us want juries to retire to consider their verdict in cases like this, that have not understood the directions of law given to them. On the whole, I welcome this trial pilot program. I think some of these areas are really quite outstanding. Others will have to be monitored during that trial period. I commend the bill.